Hello, I'm Ted Leverette, the original business buyer advocate. For more than 30 years, I've been helping people find and buy the right businesses the right way. I'm not a business broker. I don't sell businesses. I work for searchers and buyers. Most of the webinars I do, they're aimed at people searching for small and mid-sized businesses. Brokers, owners, sellers, advisors, they tune into these webinars so they know how the best informed buyers are going to think and act. Today's topic is surviving or thriving post-acquisition. It can be particularly useful for owners because they can use our insights to anticipate their future. You see, they can better prepare themselves for the ultimate sale of their business. Now, before we dive into that, I've been asked to tell you what I'm seeing amongst the searchers and buyers I'm advising. So this is not a universal observation. It's my world. And I'm working with people in various countries. So you're going to get somewhat of an international flavor. We're using state-of-the-art tactics. So what I'm about to tell you may not apply to you or your environment. So I think we feel safer because we know we're going into a minefield, but we're using best practices that are designed to handle this pandemic and financial crisis. And of course, we do this all the time, but it's even more important now. So here's what we're doing right now. One of my clients made an offer to buy a business. That was just a couple days ago. Two searchers are carefully browsing the sectors that interest them. Three searchers are touching base with all the brokers in their area because perhaps nobody is more motivated to sell a business than business brokers. So we're contacting them. Oh, and one searcher is postponing indefinitely. He might die on the vine. You know, interesting, there's been an uptick in owners who are purchasing the book that I wrote for business buyers, How to Buy the Right Business the Right Way. And I'm wondering, how many of those owners are sellers who've not been able to sell their business and they need to know what they can do to anticipate buyers? I just did a workshop the other day with an exit planner. You'll see that in an upcoming video she'll produce. You know, also interesting to me right now is there's been a slight uptick in the searchers who are asking me to review what they're doing to find worthwhile opportunities. And I think it's because the brokers and sellers are losing patience with tire kickers. They're losing patience with searchers who don't have a clue. They just don't know how to present themselves during their initial actions with brokers and sellers. And you're going to pick up some tips today on how to do that. The number one question that the searchers are asking me, what should I do with business opportunities in the context of that pandemic and the financial crisis? And you know what? That relates to the number one question that searchers have been asking me for decades. They ask, what happens after the deal closes? The answer to both of those questions, it can be found during the searcher's early interactions with business brokers, owners, and sellers. Surprise, too many business buyers don't get what they thought they bought. And it does not have to be that way. And that's what today is all about, surviving or thriving post-acquisition, due diligence, and management. You're going to hear how searchers can get a sneak peek of what they're buying. You don't have to wait for the transition of ownership and control. You can anticipate speed bumps that derail pending deals. Hunting the deal killers first. It's a mistake for sellers and buyers to think that statement only pertains to fizzling potential deals. Now, true, there are a lot of self-defeating behaviors by searchers and owners that tank deals that should have occurred. But there is something worse, done deals that should not have occurred. You see, it's no fun finding out after closing or completion that it's a dumb deal. It costs sellers and buyers. You know, buyers, they're going to sue sellers. They're going to refuse to pay them. but buyers can lose more money than the price they paid for the business, lots more. By the way, that phrase, hunting the big deal killers first, that comes from an article from the website of CPA Kevin Bassett. So here's the point. How you begin determines your ending. You need to anticipate the end game, and it'll help you begin your search on the right feet. Today, we're going to consider what typically goes wrong after closing, and why, and what to do about it, and when. We'll also consider some self-defeating actions of ill-prepared buyers, and most of these occur shortly after closing. That's when the buyers have to cope with what's wrong and try to survive it. It's also when the well-done acquisitions become even better. So towards the end of this presentation, you're going to hear about what we do to handle what goes wrong and make things better. Today, searching and buying can make sense, but only carefully. We say go slow to go fast. We say don't waste time on undoable deals. Don't waste time on unreasonable or ill-prepared searchers or sellers. You know, the most useful acquisition teams, they should, up front, before the searchers enter the buy-sell playing field, they should be alerting searchers as to what they should first focus on to detect the kinds of situations that usually derail potential transactions. You know, the kind of things that after completion can turn buyers' dreams into nightmares. We're talking about foresight here. And that's where we're going to share with you some ideas concerning surviving, if we have to, better yet, thriving post-acquisition. Because you see, if you get it right, you buy the right business the right way. I'm going to give you an example. This came from a business broker. He told me about a problem that adversely affected the company after completion of the buyer's acquisition. He said it was the buyer's due diligence failure that could have destroyed the buyer's investment. The business had a top-notch data center, which provided some of its competitive advantages. That's what enticed the buyer. But about 9 months after the acquisition was completed, the buyer discovered that the company had built its entire data center from unlicensed software. During due diligence, we're talking about more than a year ago, the searcher did not unearth that problem. So according to the broker, this is a quote, "We had a surprisingly complicated mess to sort out, and by the time the buyer discovered the problem, the deal was done. Money had changed hands. So the question was, should the buyer try to back out, try to change the terms of the deal, rescind the transaction?" Here's what Ted says. Hello, lawyers. Hello, lots of time, aggravation, money to fix the problem. How about cyber risk? You're reading about it every day in the news. It's another risk that's hurting the best intentioned deals. An attorney I talked to a while back, you can hear our interview on my YouTube channel. Just go Ted Leverette on YouTube. The title is Ted Leverette Interviews M&A Attorney Justin Daniels on Cybersecurity Risks for Business Buyers. Please look it up. Justin Daniels says, this is a quote, "Cybersecurity risk on an M&A deal can end up costing you more than the price you paid for the business. Not only have you paid for a business that does not have value, now you're in negative territory. And that can happen when you're not doing your due diligence from the cybersecurity perspective." This is really good. He gives us some examples, and he says something that's really scary. He says that quite a few of the most devastating cyber risks do not show themselves until at least 6 months after closing. Oops. So my YouTube video, he's going to talk about some of the due diligence things searchers can do. And one of the best parts is he talks about how buyers can protect themselves from the cyber risk. It's going to be a real eye opener. I'm not going to do a spoiler here, but it will change the way your lawyer writes the contract. Believe me, if you follow his advice. It has to do with making the sellers accountable after closing for their bad deeds, or maybe they're just ineptness. You're probably not going to hear this from anybody on the sellers team, and maybe not your team. So I didn't hear it until I listened to that or interviewed Justin. And say, hey, while we're thinking about reps and warranties, let's keep in mind that sellers make them supposedly to inform searchers before the deal is done. And then supposedly to protect buyers after closing. So right now, here's one of the most valuable tips I can give you. Do not rely on reps and warranties. Do your homework, hire the right advisory team, because you see, the reality is there will be errors and omissions in the seller's reps and warranties. It's normal. And there's a good chance you won't know what they are. You won't know what you don't know until after closing. And that's why you can benefit from another interview I just did with a deal-making attorney, Akbar Ali. You can see it on my YouTube channel. Here's the title: Legal Risks and Realities Amplified by the Global Pandemic and Financial Crises. And of course, what he tells us applies all the time, but particularly now. He covers like 5 or 6 huge risks, and he tells you how to handle them. Okay, let's step back and look at the big picture. The kinds of problems that can be detected before closing, like early in due diligence. Check out this chart. Reps and warranty claims by breach type. 28%. 28% relate to financial statements. So in other words, all those documents you're seeing that are labeled financial, that sellers, brokers, and others are showing you, it's the largest reason for breaches on buy-sell agreements. 28%. Now, this stuff is coming from a claim study done by an international insurance company that offers coverage for representations and warranties. Buyers can purchase it, sellers can purchase it. It's known as warranty and indemnity insurance. And it can offer both buyers and sellers a solution to cover the breaches in reps and warranties made by sellers during the transaction. Look what number 2 is over here. 13% has to do with taxation. So when you're in due diligence, you better know what you've been told by sellers, brokers, and anybody else about the taxation of the deal. Contracts. How about employment contracts and all the other contracts? 11% of the breaches to the buy-sell agreements. 10% IP. Employees. Hey, right now, employees are suing companies saying they caught the coronavirus while at work. Oops. Oh, of course, there's compliance with laws. Right now, the CDC has and other governments around the world and their agencies are telling businesses and people how to behave during the pandemic. Most people are ignoring it. Get ready for lawsuits and claims by government against businesses. And when you buy that business that was not in compliance, and I don't care how you structured the transaction, that does not stop you from getting sued. You'll hear a case in just a moment. You won't like it. Insurance is on here, but I'll cover that separately later. Don't worry, there's going to be a lot of good news in this, but we have to talk about the downside so we know why in the heck we're doing this. The claims history you're looking at, that's for mostly deals larger than a lot of you are going to be doing. The smaller deals have higher claims, higher breaches. Forget the claims. If there's no insurance, higher breaches. Why? Because those people in the smaller deals sometimes don't really know how to make a deal. They don't know how to handle the process. They may not have the best advisory team. So when things go wrong and blow up after closing, there is lots of problems. We're going to talk about the big ones and how to handle them. 1 in 7 policies worldwide reported a claim. That's about 14%. And remember, I think the actual breaches for small business are much higher because few of them qualify for warranty and indemnity insurance. So it's not in these statistics. The underwriters see too much risk in the small deals. And even if you can get it, sometimes these premiums are so prohibitive and the conditions of the policy they're just not acceptable to a lot of people who might have bought the insurance. This is interesting. Only 25% of the claims for breaches are made within the first 6 months after closing. Almost half of the breaches are discovered 12 to 24 months after closing. Now, the reason I put this information in here is I've now shown you from 3 different points of view, legal, cyber, et cetera, that most buyers are not going to know what they have until 6 to 12 or maybe 24 months. This is why I'm so hot about due diligence and talking about what I hope we're thinking about right now, what we can do screening businesses and in due diligence. And while we're thinking about insurance, be aware that there's lots of controversy right now between insureds and their insurance carriers. It's in the news. Companies think they have coverage. They don't. Claims are being denied. And that's affecting policy underwriting, the provisions of policies, deductibles, the premiums. All this is going to affect the policies to get a new one or on renewal. So when you're buying a business, you better know what it's going to look like after closing. This reality, I'll probably say this 10 more times. It really underscores the importance for searchers to detect and evaluate the risk earlier rather than later. Because you see, if you discover after closing what you could have avoided earlier, if you could have aborted the deal, it's going to take all the fun out of the merger or acquisition, don't you think? Okay, how about a few more examples? Now, these are coming from reports from insurance companies who have insured buyers or sellers. Here's one. More than 2 years after the transaction closed, the company received a subpoena from multiple government authorities with allegations that employees of the company engaged in price fixing. It could have been anything, but this one was price fixing for a period that began before the transaction and before it closed. The company was also sued in a civil action. The actions constituted a breach of the seller's representation that the business complied with all laws, and as such were covered by the reps and warranties policy. While certain criminal fines were not covered by the policy, the insurance company ultimately paid out a significant amount to cover other losses of the buyer. Imagine if there was no insurance. After closing the deal, the buyer brought a claim against the seller for the alleged breaches regarding the financial statements of the target, and also for regulatory compliance, actually non-compliance, and claims with respect to how certain funds had been invested in the past. That claim was settled with a substantial sum of money. Here's another one. After closing, the buyers subsequently became aware that a counterparty, I see this all the time, by the way, that a counterparty of the target company had been submitting fraudulent invoices to the target, that's the seller, resulting in millions of dollars in payments. The buyer pursued legal recourse against the counterparty, but also made a claim against its reps and warranty policy for breach of the warranties, for the financial statement, and material contracts. The insurance paid the claim in full. So here's another reality check. It may not be possible to afford or qualify for a reps and warranty policy. So you have to get it right in due diligence, and you've got to get it right in the legal documents you're preparing to do your deal. Later, we'll talk about, if you don't get it right, how we're going to handle it post-closing. Let's change the focus for a minute and talk about some of the things that arise after closing. These are some of the things you can anticipate searchers or business owners you can help prepare for, because it's what's going to come up when buyers and sellers are talking. So this is John Martinka. He's in Kirkland, Washington. He's been a friend of mine since the early 1990s. We've worked together in this business. He's been advising sellers and buyers of small and mid-sized businesses. He writes books. He's helped me train over 100 professionals who diversified their practices to help buyers of small and mid-sized business. John's going to share with us some insights, and then I'm going to pick up where he leaves off. So John, what can you tell us to help searchers focus on things that they can do well before submitting offers to purchase businesses? And what can they do once they get control?
Thank you, Ted. Good morning.
Good morning.
Let's talk about, before things close, before the deal closes, all the due diligence, and it really goes back before that. It starts with the relationship, and I tell both buyers and sellers, if you don't have a feeling in your gut that you're dealing with a good person, it's not worth proceeding, because something is probably going to happen on the bad side. All the things you've just been talking about. 90% of them are preventable, and people get what, term you use is buyer fever. And they ignore those warning signs, most of them having to do with people as much as the numbers and all the other things that, are pretty much concrete. But what happens afterward? Big mistakes. Buyer who wants to change things, they always have a better way. The smart buyer goes in and says, I'm not going to do anything major until at least 6 months, till I know the business, till I know the customers, I've met them, I understand the operation. I've got a handle on what the employees' strengths are and what their weaknesses are. Now, where does that come off kilter? I'd say more often than not when it's an engineering type, the tinkerer. Always has to be done a little different, a little better. I mean, I've got a neighbor like that. I mean, you tell him X and he'll say Y. You tell him Y, he'll say X. And when a buyer does that with a business, it leads to trouble. One of the things that you have mentioned to me is you can make the company smaller. And what you find, and I'll give you two examples. One is a guy who took a nice little business, and after he got into it, he said, I don't want to grow this thing. I don't want to have 20 employees. And he scaled it back to himself and his son. They make some food products, and he's making more money with himself and his son than he did with a couple handfuls or more of employees. And he's got a much different lifestyle. Now, that's one example. But another one is, I can think back to a client about 10 years ago, and Bob bought a company, and we absolutely positively knew it was overstaffed. We talked about it, and it turned out to be exactly what we predicted. He was able to get rid of a third of the employees and see no ill effects on productivity. A couple were let go. Once he came in and she saw the handwriting on the wall, she said, no, I'm going to go do something else. But you don't have to go into it right away and say, grow fast from day one. And there's another warning sign that can be prevented, and it comes back to that relationship. When the seller's going to stick around, it better be a absolutely perfect fit between buyer, seller, and what the seller's going to do. I have seen it work tremendously. Usually when the owner has been, or should I say, the owner's abilities have been outgrown by the business. And I think of one specific one that's a great example. My friend Rick bought a company. The seller, he wanted to sell. He wanted to sell the product, and he didn't want to manage people. He got into it to sell the product, and then he's managing. At the time, I think about 15, 20 employees. He didn't want to do that. A company is now probably 50 employees. And he stayed on for 3 years and was a superstar salesperson. But on the flip side is the owner who can't let go. And I can think of an example where it was the same thing. The seller wanted to be a commission salesperson, but he couldn't help meddling. And he probably wasn't ready to sell because he was getting his hands involved in absolutely everything, talking to the employees behind the buyers, the new owners back. And the same thing can happen when you've got management that's been given too long a leash, especially a key person, and they pretty much have done what they want for years. And again, that's part of due diligence. It's part of meeting them beforehand. But it's the buyer coming in and saying, this is the way it's going to be, and let's work together on it. One of the best things a client ever did, and I encourage other clients to do this, is he did a survey, and he asked the management team to fill out a survey. I think it was 5 or 6 questions, and they filled it out. And I'll share the funny one with you. To a person, they answered the following question almost exactly the same meaning, not the same words. The question: what's the biggest weakness in the company? And one of the management team wrote, the biggest weakness just walked out the door. And boy, to talk about getting off on a good foot with the employees. And they knew he was listening. They knew he cared. And the collaboration prevented any, should we say, unrest or a coup to take over from the buyer who wasn't as knowledgeable as they were about the business. Anything else you'd like me to talk about?
No, I think that was pretty important. It's right on point. Let me begin, or let me resume with some of the questions that were asked by some of you when you registered for this webinar. And then I'm going to talk about some of the most common topics that cause the problems after closing, and all of which, one more time, buyers can anticipate, and you can mitigate them or avoid them. Okay, Bob. Bob asks, what percentage of deals have you seen that fall through, never to return, or fall through but likely will return later, or are still proceeding but probably at a slower pace? Okay, here's my answer, Bob. Nearly every deal that gets done almost dies a dozen deaths. Worthwhile deals occur for buyers and sellers who have a competent advisory team without conflicts of interest. Principals talking to each other can sometimes stink up the works. You can amplify problems. So the way I handle it with my clients, because I don't think advisors should be mouthpieces directly with sellers, for example, except in rare instances, we rehearse. I work with clients to rehearse how to handle the situations when the deal's about to die. I have a client in England who completed a deal in March, and that deal many times could have fallen apart. But he and I, my client, we spent tons of time on the phone or Zoom, and we rehearsed and talked about how to handle the seller, the seller's team, and just about everybody else, key employees. So each time we hit a speed bump, we figured out how to handle it, and my guy practiced with me until it was near Academy Award-winning performance. And then he went back to the owner or whoever was on the other side, and he caused the people to calm down. Now, Matthew asks, how do you manage brokers' negotiating behavior? Oh, this is good. It's like managing cats. Okay, here's my answer. Be authentic and transparent, buyers and searchers. Show the value you bring to the table, and then expect the same in return. Walk away from brokers and sellers who won't reciprocate. If they're not authentic, if they're not transparent, if they're not acting in a timely fashion like you are, get out of there. Go to the hidden market. Look for opportunities that are not represented by brokers, for example. And by the way, just for the record, if you're working with a good broker, stay with them and continue to look for additional opportunities. Now, John asks, how possible or probable is it to fund the majority of a purchase through a combination of leveraging the business's assets and seller financing? Okay, I hope this didn't come from somebody who took one of the get rich quick courses that I think are bullshit. I can't answer this in this webinar. It's way outside the scope of what we're talking about. Contact me privately, anybody who wants to do these no money down deal things, and I'll give you a reality check. It's not that they never get done, but they're so rare and they're so treacherous. It's just not worth our time to think about it. But what I want to think about that has something to do with something scary, it's the real big bugaboo. Seller discretionary cash flow. Let me look at our chart. Look at this in red. Seller discretionary cash flow and other prevalent pitfalls. And I'm talking about seller discretionary cash flow and all its cousins, such as owner's discretionary earnings. The key words are cash flow, meaning net cash flow, and earnings. And I have those in quotation marks, cash flow and earnings. Brokers and sellers have perfected the calculation of the number that they and some buyers use with a multiple to arrive at what they say is value. That's in quotation marks. And what they say is value, or the asking price for the business for sale. This topic is way too complicated to cover now, but I am telling you, make sure you have an advisory team who knows how to compute this, knows how to handle it, does not have a conflict of interest. You need to know how to interpret those adjustments to the financial statements, the historical as well as the forecasts that are being shoved at you. And you better look carefully at this word called discretionary, that's in quotes. And you better look at the word carefully, multiples, that's in quotation marks, that are being used for pricing businesses. Everything can go wrong from there. When I'm screening for buyers or helping buyers in search, this is one of the first things we look at. And our BS meter is running, and if we don't feel good about it, we usually dump the potential deal because it's just ridiculous to continue because the expectations are too unrealistic on the other side, the seller side. You know, getting this wrong creates disgruntled buyers because if they do deals based on phony numbers or wishful thinking numbers, they're going to want to seek recourse against sellers. They're going to re-examine everything the seller told them way back during due diligence. And they're going to pick apart the purchase contracts. They're looking for a crack, some way they can gain leverage over that seller. And that's why you searchers need to be anticipating and discovering these risky situations. You need to be doing it up front with your legal counsel and with your other advisory team members. Because as you're going to discover, some of these things have no recourse. One of the big ones are landlord problems. What if any, and you need to be asking this, what if any relationships and obligations have arisen or changed due to the pandemic and financial crises? I'm not going to give you examples. You're reading about them. Huge problems out there. Some you're not going to know about for a while. What about the lease? You know, landlords might approve a lease assignment, but they might not cooperate on the renewals. They may change the name of the game on how they support the tenant. So you need to be asking, how has the landlord complied with the lease? That's what you're asking these owners. If I were you, I'd be getting that answer in writing, because if you don't expect any improvement from these landlords. These landlords are not getting paid. They're struggling. What happens if the landlord goes into bankruptcy and there's a foreclosure of the property? You better ask your lawyer about that. Don't think that lease is protecting you. And by the way, does the lease permit the landlord to lease to your competitors? You've got businesses going out of business in industrial parks and in strip malls and other kinds of locations, office buildings. You want to have another business like yours that you reopen or is open, comes in down the way where another business closed? Okay, here's another risk you can anticipate and maybe you can handle after closing. And that's the overextended manager or the employees. So you need to be asking, to what degree is the business dependent upon the existing owner? Delegation is a way to avoid overloading, and so is priority management, which means doing what needs to be done and doing the rest later. Too many self-imposed deadlines are self-defeating. John Martinka is big on this thing called owner dependency. Read his book. This is really a bad thing if you're a buyer stepping into that kind of business. Okay, how about, this comes up all the time, how about a company that's too dependent on a key employee or key employees? You know, they can hold you up after closing. And it's kind of similar to a revenue concentration with customers. That's why we like to see cross-training of employees. It's one way to keep the business running smoothly if a key employee gets frisky or quits. So you want to ask, what have you done to cross-train your employees to cover if you lose that? Hey, what about a key employee who right now has the coronavirus? Oops. Oh boy. What you really need to do is ask what it's going to take to keep that key employee to stay involved and to do peak performance. You might have to offer a contract. I've had buyers, in fact, I suggested, who before closing enter into a contract to become effective simultaneous with the closing of the purchase that commits the key employee, not only to stay, but to perform at certain benchmarks. I've had them even buy key man insurance on those key employees. Now, how about this one? This is, you're seeing it right now. Suppliers demanding better terms. You can ask the owner, how have the suppliers been behaving during the pandemic? How did they handle this business during the Great Recession back in 2008 or 10? You know, supplier competition, it is the antidote to unreasonable demands from vendors or suppliers. But they got to be in business. They have to be able to ship. I mean, look at Amazon. I tried to buy this green screen sitting behind me to make this video, and the one I wanted, I couldn't get because Amazon just basically wouldn't let you place an order with them because the supplier couldn't guarantee delivery during the pandemic. The entire supply chain is being disrupted right now. So you need to be deeply looking into this, and this could be some conditions in your contract. I'm not exactly suggesting earnouts at this moment, but I am telling you, these are some of the things that cause for pricing to be flexible. These are some of the things that discount what would be the normal value for a business that you're being told it's worth. Oh, what about some more ideas about people resources? Well, it's the employees, it's the customers, sure, the suppliers, they're the big ones, they're the big actors. So here's what you need to do, buyers. Immediately after closing, do what it takes to favorably impress them. I don't mean take them to lunch or send them a Hallmark card. You need to nourish those relationships with the highest performing employees and suppliers. You need to make it worth their while. And while you're relationship building with your key employees, ask them to what extent they think you should weed out the worst employees. They know who they are. Chances are they're going to encourage you to get rid of the slackers, get rid of the incompetents. Why? Because those losers usually make work more complicated and less fun for the best employees. So here's something somebody said to me. Listen carefully, think about it. Change employees or change employees. People searching for businesses to buy are, well, you want to carefully consider the physical and cultural changes. Look at what we're seeing in the news right now every night, cultural. the physical and cultural changes that are going to be necessary to keep the business in business, to keep the premises safe, the environment healthy. These are all things you need to be asking owners about. And what are you going to have to do when you get control? And what's it going to cost? Exactly what is it going to cost? Yeah, I'm in South Florida. It's June. We're entering hurricane season. We're going to have a hurricane or two. Businesses are opening up in this pandemic. Then hopefully that will diminish, but we still have the financial crisis. Then we're going to have floods, and roofs are going to blow off. What's it going to cost for all that? You better build that into your pricing and how you're going to make payments on the business you buy, buyers. The good news is the media is screaming about this, so you can see about the changes. Just read those stories. Some of them are going to be temporary, some long-lasting. Your purchase and sale agreement, your pricing, your payments need to accommodate all that. Now, here's a big one. When the face of the company about faces, you see, it's not always the company owner that the marketplace perceives to be the face of the company. It might be somebody in marketing, in technology, maybe customer service. Companies that are flying high can quickly go into a tailspin if a material change of behavior arises that causes the company's previously marvelous spokesperson, you know, the face of the company, to pivot in the wrong direction. You're seeing that right now, again, in the crisis. The way people are behaving, it's causing people to lose their job, and it's causing companies to go into tailspin. Look at Facebook. I'm no fan of them. They're experiencing this right now. Look at their marketplace reputation. Look at their perceived capability. Look, it's not good for a company when the face of the company about faces or falls on its face. And it's also not good if the company has not worked on its succession plans for the owner, the key employees, and key stakeholders. So you got to be asking these owners, what have you done? What are your succession plans? None? Holy cow. Why do you think there's a whole industry of exit planners out there trying to get the attention of owners? Well, you buyers got to pay attention to that, because those things the owners are not doing, you're going to get to pay for them later. You better put that in your pricing and your payment plan as you're paying off sellers. What about the seller who didn't produce adequate records? Well, you asked for the information, didn't you? But you didn't get it, or it was not sufficient. Now, besides not having enough worthwhile information to make an informed decision, you know, about purchasing the company, if it turns out your business buying attempt is a disaster, you might not have sufficient legal standing to enforce contracts. You might not have the documentation to use against the seller or other parties to the transaction. You better talk to your lawyer about that. What's the reality about enforcing breaches? One more thing that I see go wrong all the time, you can handle this in the first interview with sellers and brokers. If you don't, you get to pay for it later, but let's talk about it. Don't forget post-acquisition, after tax cash flow. You see, payments on acquisition debt should not be more than 50% of net profit. I know we can argue about that, but some number. Don't use too much of it, because if your payments on acquisition debt exceed 50%, trade credit can be harder to get, and your risk of insolvency grows. You see, this happens because buyers do not realize that the principal portion of payments is paid in after-tax dollars or pounds or lira or euros. After taxes, how that principal is being paid. And it does risk a cash flow crisis if you get it wrong. And that is a sad reality. You need to find out early what part is interest, what part is principal, and where is the cash going to come from. Here's one more. John sort of mentioned it. I'm going to delve a little deeper because I'm talking to this with exit planners right now. Inadequate transition assistance by sellers. Those of you who've been around, you know that's what you can expect. Nearly all the buyers are overwhelmed with work and uncertainty during their transition into the company. It's normal. Get used to it. Get ready for it. Nearly all business acquisitions suffer post-acquisition trauma. Now, some of it a buyer can avoid before closing by contracting with the seller for post-acquisition assistance and training. And then after closing, enforcing the agreement. See, regrettably, too many former owners, they just do not comply with the promises they make about transition assistance. So you better make it enforceable. This is why you need a good lawyer. You can't have a lawyer, by the way, who writes clauses that are so egregious that nobody would sign them. You got to have a deal-making lawyer, the kind of people I work with, my clients work with, I hope. You know, sellers who are financing carrying paper part of the buyer's purchase price, they're more likely to provide worthwhile transition assistance to the buyers after closing. Why? Because they want to get paid. If they didn't help finance it, Transition assistance is especially important if the value of goodwill is a significant part of the purchase price. Perhaps as important as the former owner's transition is the insight and help from the company's employees and your transition advisors, buyers. Okay, here's what I'm telling buyers to do right now. Oh, I should say I'm advising them to do. Get more intensive transition assistance for a longer time after closing from the exiting owners. Explicitly define it in the purchase and sale agreement and in any other kind of agreement, such as an employment or consulting agreement with that exiting seller. And for example, after closing, we want former owners to personally introduce us to the key employees, to the suppliers, to the key customers. I don't mean send an email. I mean hold our hands in person, introduce us at our side to the key customers, suppliers, employees. And then by contract, strive with us to improve the relationships. Again, this deal that I recently did in England, the seller's staying on for quite a while and is highly motivated to do this and is doing a great job helping my client, the buyer, embed himself with the customers, suppliers, employees. Okay, now what if the seller says no to all this? Well, here's a reality check, folks. It's discretionary to buy a business, but it's not discretionary for owners who must sell their business. You see, buyers can sit on the sidelines. We don't have to do deals, but some owners must make the sale of their wonderful business, and they need to do it now for maybe a personal reason. That's how they protect their investment. They make a sale. So remember this, searchers, businesses for sale are like buses. More will be by soon. Okay, a few more things. You bought a job. I know people out there unemployed. Don't jump from the frying pan into the fire. It's not a good enough reason to buy a business because you hate your job. You can't find another one. You know, buying a job, most of these businesses are so small, they're basically losers in waiting. A worthwhile business acquisition should fairly compensate at market rates its working owner for managing the company, plus provide a decent return on investment, plus return the capital investment to the purchaser. You see, anything less, it's questionable, to say the least. And you don't have to run the company, by the way. Again, this deal I just did in England, my guy is not running the company. He created a board. He's providing strategic advice. It has management. And by the way, you can get these companies at prices below $2 million. They have management. Anything less is just too questionable. As I said a moment ago, keep in mind these smallest deals, they are the riskiest to own. They're the hardest to manage. How about a few more tips? This is something I got from divestipedia.com. It says, the reality is that any transaction always contains unknowns and unforeseeable risks. Despite conducting the best due diligence, the unknowns remain until the dust settles long after the deal is done. So I'm going to say it again, do not rely on reps and warranties without good reason, and have an absolutely wonderful deal-making lawyer, somebody who knows how to facilitate deals, not kill deals that should happen. See, I think the time for legal due diligence, now we're talking legal due diligence, not commercial due diligence, legal due diligence, it happens up front. So that's where you get your lawyer involved. So as you're getting involved in viewing a company, get the legal done right away. Is this company properly structured, properly licensed? Do the people own what they say they own, etc.? I'll say it again because I want to be on record. Do not be comforted, or at least overly comforted, by the reps and warranties. What if recourse cannot be achieved? During the initial interview with sellers, early in due diligence, that's the opportune time to learn about this stuff. And here's one more. This is the last question you ask, or you ask it as you go along. You ask everybody you're talking to, is there any information that you know of that has not been disclosed to me, that you haven't disclosed to me, which might have a bearing on the viability or value of your business? And then write down what they say, staple it to the purchase contract as part of the reps and warranties. This is pretty important. Buyers suffer dumb deals because they ignore this truism. You can pay too much for a good business, but you cannot pay too little for a lousy one. The problems we've considered today stem from defective acquisition techniques, not lack of good businesses. That's why I have numerous searchers out there right now looking for deals. Now, we're being careful making offers, but we're looking because there are lots of good businesses, and we don't want to wreck them with defective due diligence. Let's talk a little bit about search, because people sitting on the sidelines, you're really missing out. It's always a good time to be searching for these small and mid-sized businesses. And it's a good time to buy if what? You buy mature, profitable, fairly priced businesses that have sustainable competitive advantages. And if the deal is done in the context of economic circumstances, and your terms of purchases are flexible enough to handle what's coming. So searchers, look, buying a business, it is all about search, because if you can't find it, you cannot buy it. But you got to be best, and you got to be first, and you have to be first on scene with the brokers and with the sellers. You have to be their first choice, because there's a lot of buyer competition out there. Granted, a lot of it's dumb competition, but it's still there. So you have to be top of mind with the brokers and sellers. And you really have to avoid buyer competition. Otherwise, you get to what? Outbid them. Not a good thing. Searchers, you need to get a winning business buyer marketing plan. This is sort of the commercial for me right now. That's what I do for a living, help position searchers to be better and look better. You can learn about how we do that in one of my books, How to Prepare Yourself and Find the Right Business to Buy. And if you're already looking at a deal, or if you're thinking of selling a company, well, How to Buy the Right Business the Right Way. That book is going to show you how the savviest people get deals. So you will save time, you will save money, you will achieve better deals if what? You do what the savviest buyers do. Folks, I'm available. I can help you deploy the tactics in the books. I can help you deploy what you've learned right here. Go to my website, partneroncall.com. I'm Ted Leverette, the business buyer advocate with Partner on Call Network, saying thanks for listening. Okay, we done.